can see a note on the chat room. The answer is no, they will not be uploaded to Sol. So this is actually being video recorded, as you well know, and the video recordings will end anyway in about, I think, 3 weeks. So no, there won't be anything else which will be uploaded to Sol, not until your revision course. Okay, this is our lecture 8. We have finished ROT and we've looked at a question on ROT. Let's move on and let's look at the seller's remedies. The unpaid seller has 2 types of remedies. In personam, which means the seller has rights against the buyer personally. There are also in rem remedies, where the seller has the rights against the goods. Now, our syllabus essentially only deals with in personam rights. The first thing to ask is what or who is an unpaid seller. Section 38 says a seller is unpaid when any part of the price has not been paid. Let's look at damages for non-acceptance. If the buyer does not accept the goods, the seller is entitled to Section 50 damages. This is the difference between the contract price and the market price when goods ought to have been accepted. If no time has been fixed for acceptance, then we're talking about at the time of refusal to accept. A simple example. I agree to sell to the some bananas to the buyer for $1,000. The buyer refuses to accept delivery. The best price I can sell them for in the market is $800. So my claim under Section 50 is $200 from the buyer. Now, damages for non-acceptance under Section 50 is very similar, of course, to damages for non-delivery under Section 51. Both require the market rule. In other words, the difference between the market price and contract price. So here we're looking at the seller's remedy. So when the buyer refuses to accept goods, the seller clearly is entitled to damages. How much? Under the Sale of Goods Act, it's Section 50, the difference between the market price and the contract price. Now, in addition to Section 50, the seller can also sue for damage under Section 37. Section 37 says, where the buyer refuses to take delivery within a reasonable time, the buyer is liable for any loss and for a reasonable charge for the care or custody of the goods. Remember Section 20 sub 2. We looked at this in the first lecture, maybe the second lecture. Section 20 sub 2 says risk is on the party at fault. We know the case of Denby Hamilton against Barden. This involved a contract for 30 tons of apple juice. The buyer was delayed in taking delivery and the juice went bad. The court said the buyer bears the risk. The buyer must bear the loss. If the seller incurred storage charges, then the seller can claim for those costs against the buyer under Section 37. The second of the seller's remedy is in personam, is an action for price. Under Section 49 sub 1, the seller can sue for price if 2 things. First of all, property has passed to the buyer, and secondly, the buyer refuses to pay. Now, if property has not yet passed, the seller cannot sue for price. The seller can only sue for Section 50, damages for non-acceptance. But this is exactly what happened in Caterpillar against Holt. We looked at this case yesterday. The seller sold generators to the buyer under an ROT clause. The buyer then resold the goods to a sub-buyer. The buyer refused to pay. So the seller sued the buyer for price. The Court of Appeal said the ROT clause was effective. The seller retained title until he got paid. Caterpillar Court of Appeal went on to say that Section 49 is the only way seller can sue for price. And since property did not pass to the buyer, the seller cannot sue the buyer for price. But you and I know that the Supreme Court case of res cogitans, now there were 3 questions for the court, if you remember. Question 3 was, is Section 49 the only way the seller can sue for price? Lord Mount said, no, Section 49 was not a complete code of situations where price is recoverable. The Supreme Court said they would overrule Caterpillar on this point. You see, the seller usually wants to sue for price. That's because an action for price is higher than damages for non-acceptance, because the court does not have Williams against Agius discretion to reduce the price agreed between the 2 parties. You see, Williams against Agius is a House of Lords case. Facts don't matter at all. It gives the court enormous powers to reduce the amount of damages awarded to one party. But when we're talking about price, price is something courts have no discretion at all. The reason for that is because it is up to the buyer and seller to make their bargain. Party autonomy. You agreed to buy my pen for $1 million, or I agree to sell you my brand new Rolls Royce for 10 cents. The court has no discretion at all. The courts cannot change the price that you and I agreed. Party autonomy always wins when it comes to price. That's why, you see, the seller usually wants to sue for price, because an action for price is higher than damages for non-acceptance. Now, there is one other way the seller can sue for price under the Sale of Goods Act. Section 49 sub 2 says the seller can sue for price if, firstly, the price is payable on a particular day irrespective of delivery, and secondly, the buyer refuses to pay. Note that the goods do not even need to be appropriated to the contract, but the seller can sue for price. Now, I've got 2 examples on the screen. The first example, let's say the contract term is payment due 30 days after delivery. If the buyer refuses to pay, can the seller sue for price? The answer is no. Section 49 sub 2 does not apply. Look at the example 2 on the screen. The contract term now is payment due 30 days of invoice. The answer is yes. Section 49 sub 2 does apply because payment is irrespective of delivery. Payment is not dependent of delivery. Now, those are the seller's rights in persona. The unpaid seller also has remedies in rem. This is where the unpaid seller has rights against the goods themselves. The unpaid seller has rights in rem whether or not property has passed to the buyer. Remember, the seller is an unpaid seller if any part of the price has not yet been paid. That's what Section 38 says. Now, the first in rem remedy is ROT, retention of title. Well, we've done this as a whole topic. Remember, the starting point is Section 19. If the seller reserves his right of disposal of goods until certain conditions are fulfilled, property does not pass until those conditions have been fulfilled. This is the basis of all ROT clauses. Until the buyer pays, the seller retains property in the goods. So if goods remain unmixed and they are unsold, the seller can retake those goods. We know Ramalpa, Clough Mill against Martin. Even if goods are mixed, but they remain identifiable, it's okay. Hendy Lennox against Graham Putting. That's the diesel engine case. In the matter of CKE is another case we looked at, the zinc ingot case. Remember, ROT must be an express term of the contract. ROT clauses must be expressly incorporated. Now, the unpaid seller does have other in rem rights, but these are not in your syllabus, so there's no need to talk about them. Let's look now at consumer contracts. Okay, now consumer contracts are governed by the CRA 2015. So what is a consumer contract? Well, it's a contract whereby a trader supplies goods, digital content, and services to a consumer. So who is a trader? Who is a consumer? You will find the definition in section 2 of the CRA. A trader is someone who acts in the course of business. Now, a consumer must be an individual. In other words, a natural person. Companies cannot be consumers. Businesses cannot be consumers. And you are only a consumer if you do not contract in the course of business nor holds himself out as doing so. Okay, so we know what we mean by trader. It's essentially anyone who acts in the course of business. But this includes lots of things like government departments. These are also traders. Or in fact, a charity shop who sells a t-shirt, they are also traders. As long as they sell in the course of business, bang, they are a trader. The consumer must be a natural person. So it must be people like you and me. Businesses cannot be consumers. Now, what do we mean by goods? We discussed the meaning of goods for B2B contracts. For B2C contracts, the definition is in section 2, CRA. Goods is anything physical which can be moved. So buying a pet dog is buying goods. The authority for that is Pendragon against Kuhn. We will look at this case later. So the CRA does not apply to land or a house because they cannot physically be moved. Goods does include water, gas, and electricity if it is sold in containers. So a bottle of water is goods. A gas cylinder is goods. A battery is goods. Wormel against RHM applies to consumer goods. So remember when we looked at Wormel against RHM, we said goods means everything supplied with the goods. So if I buy a bottle of Coca-Cola, nothing wrong with the Coca-Cola inside the bottle. But the bottle has a small tear and the Coca-Cola is leaking. Well, the goods will be defective because goods includes everything supplied with the goods. CRA covers the supply of goods, digital content and services. Supply does not mean just sale of goods. It includes the hire of goods. So I hire a bicycle for the day. This is covered under the CRA. The CRA also includes the transfer of goods. This is section 8 of the CRA. So a free gift is covered under the CRA. It's not a sale of goods because there is no money consideration, but it is a transfer of goods. So under the CRA, freebies must meet goods requirements as far as satisfactory quality and fitness for purpose is concerned. CRA also applies to mixed contracts. For instance, if I get my car serviced, this involves labor, that's the service and service part, and it involves materials, the bits that need to be removed and cleaned, the car parts. Under the CRA, the service bit is covered by the service provisions. The goods bit is covered by the goods provisions. Now, many of these provisions are very similar to the Sale of Goods Act. Yeah, sure, different section numbers, of course, but the remedies are different. But where the provisions are very similar to the Sale of Goods Act, I won't bother to repeat it because you and I have covered it in full. The first provision is Section 9, Satisfactory Quality. Now, this is the same under the Sale of Goods Act. It is an implied condition that goods must be of satisfactory quality unless the defect was brought to the attention of the buyer or that examination the buyer carries out ought to have revealed the defect. We know all of that. The meaning of satisfactory quality is exactly the same under the CRA. Goods are satisfactory if a reasonable person would regard the goods as satisfactory, take into account description, price, all other relevant circumstances. You and I have covered all the cases. So if it is a B2C contract, you're talking about a consumer and CRAs involved, you use the same cases we looked at under the Sale of Goods Act. Description, we know what that means. New car, old car. We've got 2 cases for new cars, 2 cases for second-hand cars. Price, high price, low price. We have all of that. The only thing which is new is goods are satisfactory if a reasonable person would regard the goods as satisfactory, take into account description, price, exactly the same as Sale of Goods Act. The third thing is all other relevant circumstances. Now, this bit is different. Under the CRA, all other relevant circumstances, the satisfactory definition includes public statements on the specific characteristics of goods made by the trader or the producer, particularly in advertising and labeling. Now, this is quite a significant development in the law. So the motor car dealer in a small English village, he is responsible for Toyota's statement in the head office in Japan. So if Toyota HQ advert says, oh, the car has 248 horsepower, if this is incorrect and the consumer bought the car in a village town in England, then whether the car is satisfactory or not, you take into account what that advert said. So you can imagine the chaos, of course, that would arise if, let's say, I don't know, Toyota's employee played a practical joke. Maybe the advert says, oh, the car can fly. Will Toyota, the employer, be liable? Don't know. I mean, there are exceptions to this new bit, of course. Satisfactory quality definition includes public statements on the specific characteristics of goods unless, and there are 3 exceptions, unless, firstly, the trader is not aware and could not have been aware of the statement, or, second exception, the incorrect statement was withdrawn or corrected before the contract was made, or the third exception is the decision to buy goods was not influenced by the statement. So, for instance, if the advert said the car can fly, well, if that is so rubbish that it is arguable that no reasonable buyer could have relied on. Aspects of the quality of the goods is exactly the same as we discussed before. Goods must be safe, it must be durable, safe, and so forth. No need for me to remind you. We've done all of that. Section 10, fitness for purpose. This is the same under the Sale of Goods Act, where the buyer expressly or impliedly makes known the particular purpose for which he requires the goods, the goods must be fit for that particular purpose unless buyer does not rely or it was unreasonable for the buyer to rely on the seller's skill and judgment. We've done all of that. A hot water bottle must be fit as a hot water bottle. Use exactly the same cases as we did before. Just copy and paste. Section 11, description. This is the same under the Sale of Goods Act. There is an implied term that goods must match the description. It doesn't matter how small the breach. The strict compliance rule applies. So 1/16 of an inch too thick would mean a breach. Now, if the buyer examines the goods, the answer is yes, it is still a sale by description. That's section 11, sub 3. You and I know the case of Beale against Taylor. Just note section 11, sub 4. 11 sub 4 talks about the CCR 2013, the Consumer Contracts Regulations. There is no need to know the CCR in any detail for our syllabus. There's only a few bits that I want to mention. The CCR, the Consumer Contracts Regulations, says that the trader must provide certain pre-contract information to the consumer. Now, one piece of information is the main characteristics of the goods. Now, the trader does have to provide more than just this, but section 11 description only refers to this one bit of information the trader must give, the main characteristics of the goods or service. But this is not onerous at all. The information is usually on the package anyway, or it's on a poster next to the washing machine. It will say, oh, super quiet. It will say 5 kilogram loads. It'll have that on a poster or on a sticker anyway. What we're saying here is if the shop assistant tells me, the consumer, that the washing machine does a super fast wash and it's not true, this would be a breach of section 11. The remedy is under section 19, 5 R's. We'll see the 5 R's later. The consumer has lots of rights, 5 R's. Section 12 talks about other pre-contract information. Now, this is completely new and we don't have the equivalent under the Sale of Goods Act. Pre-contract information, as far as the main characteristics of the goods, are already an implied term under section 11 description. Section 12 is saying other pre-contract information is also part of the contract. So if the information is not true, the trader is in breach of section 12. But the remedies for breach of section 12, it's not as huge, not as big as for breach of section 11. You can get some money back, but not the 5 R's, which we will see later. There is no need, as I say, to know the CCR 2013 in any detail, but pre-contract information essentially is 3 things. Firstly, the identity of the trader. Well, this is usually pretty obvious. The shop sign will say Mannings. It will also be, one of the things also is the identity of the trader. You must have the address and the phone number as well. The second thing is the price of the goods and service. But this is already usually, the box is already labeled with the price. The third thing is if it is a sales contract, a reminder that the trader is under a legal duty to supply goods which conform with the contract. Now, the trader must give information only if it is not immediately obvious. Sometimes, so for instance, some things are obvious. The address of the trader is obvious because I am physically standing in the shop, so I know the address. So in that case, the trader doesn't have to tell me his address. because sometimes it's obvious. Now, the information must be given to the consumer pre-contract, because the information must be pre-contract information. So where is that in the shop? You tell me. If I'm in the shop, where must this information be presented to? Where is a contract made in a shop? Do you remember your Lecture 1 contract law? Where is the contract made? You would have studied Pharmaceutical Society of Great Britain against Boots Cash Chemist. Thank you very much. You are absolutely right. The answer is at the cashier, at the cash till. That's where the contract was made. That would have been your very first lecture of contract. Remember, when goods are displayed on the shelves, those are just invitations to treat. It is the customer who takes the goods from the shelf, puts them in the basket. It is the customer who is making the offer to the shop. The shopkeeper will accept by ringing the cash till. That's where the offer and acceptance is made. So at the very latest, it's at that point that information under the CCR must be given to the consumer. Now, there is one important exception to that rule. The exception is that the CCR does not apply to day-to-day transactions which are completed immediately. For instance, if you go and buy groceries in a supermarket or you're getting a Starbucks coffee, well, consumer already knows about the goods and the cost, so there is no need for pre-contract information. But in less routine transactions, if you're buying washing machine, furniture, fitted kitchen, the trader must give pre-contract information. And the burden of proof is on the trader that the information is given. Now, Section 13, sale by sample, similar to the Sale of Goods Act. Goods delivered must match the sample. So if the consumer is buying some curtains, it must match the swatch, the very small example that the trader would have shown, the shop assistant showed me. It must match as a swatch. So very simple, no more for us to say about that. Now, Section 14, match model, well, this is new. Section 14 says it is an implied term that goods must match model seen or examined. Example. I go to a shop and I see a washing machine displayed in the shop. I agree to buy one. Usually, of course, what is delivered to me is not the one I actually saw in the shop, because mine is brand new. It's in a box in the warehouse. What Section 14 CRA is saying is what is delivered to the consumer must match the model displayed in the shop. The difference between Section 13, sale by sample, and Section 14, match model, is this. Sample means the consumer just sees a bit of what they agreed to buy. So if I want to buy some carpet, I'm just looking at a bit, a swatch. Sale by sample means the carpet delivered to me must match that swatch. Model means the goods must match what I see in whole. So the washing machine, I saw the whole washing machine. What is delivered to me must be the same as the model or the color as the one I saw in the shop. Section 15, goods must be installed correctly. Otherwise, that's a breach and the consumer is entitled to the goods remedies. Section 16, if digital content supplied is defective, that's a breach and the consumer is entitled to the goods remedies. Now, Section 16 applies to digital content supplied on a disk, but we don't need you to know Section 16. It's not even in your syllabus. I just thought I'd mention it because it's between 15 and 17. All right, that's all. You don't even need to know Section 16. Now, Section 17, you need to be aware of, because Section 17 talks about title. This is exactly the same under the Sale of Goods Act. It is an implied term that the seller must have the right to sell goods. Liability is strict. We know the Sale of Goods Act case, Rowland against Duval. So you see, the CRA provisions are not so different to the Sale of Goods Act provisions. What you need to do is to copy and paste. So if your exam question is a B2C, it involves a consumer, then you're still using the same cases for satisfactory quality, same cases for fitness for purpose, everything's the same. So you just copy from your Sale of Goods Act notes into your CRA. The few bits which are different, I've covered. Now, remedies, however, is very different. Let's look at CRA remedies. Note straight away that Section 34 of the Sale of Goods Act applies to B2C contracts. Section 34 Sale of Goods Act says the buyer must be given a reasonable opportunity to examine goods. But for the consumer, there is no concept of acceptance. Remember, Section 35 Sale of Goods Act says buyer can lose his right to reject in 3 ways, but Section 35 does not apply to consumers. Only Section 34 applies. The consumer must be given a reasonable opportunity to examine the goods. Section 19 of the CRA sets out the consumer's remedies. The details are all set out in sections 20, 21, 22, and 23. Essentially, the consumer has 5 rights, 5 R's: reject, repair, replace, reduce, reject. You can see from the diagram that for most breaches, the consumer gets 5 R's. Not for breach of Section 12, but that's for pre-contract information. So if the shop does not tell you their phone number, it's not a big deal. It's not a massive breach. You might get some money back, but even if you did, it wouldn't be very much. For breach of Section 15, there's only 4 R's. That says, Section 15 says, goods must be installed correctly. Now, if they are not installed correctly, then the consumer has only 4 R's. The missing R is the first one. In other words, if the goods are not installed properly, then the consumer cannot reject the goods. Because, you see, they've just been installed. They have been installed, but it's just that the workmanship is poor. The consumer does have the other 4 R's, just not the right to reject the goods. Note that breach of Section 17 title is special. It's not the short-term right to reject. It's not the final right to reject. It's special. The consumer just rejects. Okay, let's look at what each of these R's mean. The first R is the short-term right to reject. If goods are defective, the consumer can reject within 30 days of taking delivery. If the consumer wants to reject, of course, he must actually reject. He can't sit at home grumbling about it. It does not matter how the consumer rejects, but it must be clear that he is rejecting. A phone call is absolutely fine. It doesn't have to be in writing. Note that the right to reject within 30 days is not a 30-day guarantee. It will not apply if it is inconsistent with the nature of the goods. So, if I buy a bunch of bananas, I don't have the full 30 days to reject because I can tell very quickly whether the goods are defective or not. Note again that the short-term right does not apply to Section 15 incorrect installation of the goods, because in that case, you only get 4 Rs, because the goods have been installed, so you can't reject them. It's just that what you're saying is the installation is just not as good as you were hoping to. That's why you end up with only 4 Rs. Now, when the consumer rejects, the trader must refund the consumer without undue delay, at the very latest within 14 days. The consumer, in that case, must make the goods available for collection by the trader. Remember, the CRA applies to the supply of goods, not just the sale of goods. It applies to hire of goods. So, for instance, if hired goods was defective, then the consumer cannot claim a refund for the period of time that the consumer had use of the goods. Let me make up an example. I hire a bicycle for 4 weeks. 3 weeks later, the bicycle blows up. It's clearly defective. I reject. I cannot get a full refund because I did use the bicycle for 3 weeks already. So the maximum I can get is 1 week's refund. Now, although the consumer has the right to reject within the 30 days, the consumer does not have to reject. The consumer has the remaining 4 remedies, the 4 Rs. The consumer, instead of rejecting, can demand that the trader repair or replace. Now, if the consumer demands repair or replace during this 30-day rejection period, time stops running. The CRA calls this the waiting period. Time is suspended when the consumer demands repair. Time is suspended until the consumer gets the goods back. Then the consumer has the rest of the 30-day period or 7 days after the waiting period to check if the repair or replacement is okay, whichever is the longer. If goods are still defective after repair or replace, the consumer can still reject. Otherwise, the consumer still has 2 Rs. Now, of course, if the consumer has lost his short-term right to reject because he's trying to reject more than 30 days after delivery, he can only ask for repair and replacement only. So what happens essentially is this. Let's say I'm the consumer. The goods are defective. I demand the trader repair it. Then it is the trader's choice. Maybe repair is too expensive. So the trader chooses to replace it because it might be cheaper for the trader to get the manufacturer to send me a new washing machine. Of course, the seller must bear all the necessary costs, so the seller pays for delivery charges. If it is not possible to repair or replace within a reasonable time, maybe it's already an old model now, then the trader and the consumer, we can negotiate a reduction in price. If we can't come to a solution, then the consumer has the right to final reject. Treat that contract as terminated, rescind the contract. If the consumer has had the goods for less than 6 months, the trader must give me a full refund. If the consumer has had goods for more than 6 months, the trader can reduce the refund to take account of the use I had of the goods. Now, there's one exception to this rule, actually: motor vehicle. Even if the consumer had the car for less than 6 months, the refund can be reduced to take account of use of the car. Question: when must goods be satisfactory or fit? With the Sale of Goods Act, we said, oh, that's at the time of delivery. Crowther against Shannon Motors. Because we said the car breaks down after such short period of time after delivery, that is evidence that at the time of delivery, the goods were already defective. We also know the case of Hazelwood against Lion Foods. The FSA had a zero tolerance for Para Red at the time of delivery. With the CRA, goods must be satisfactory and fit at the time of delivery. So that is the same. But as far as the short-term right to reject is concerned, it is the consumer who must prove that the defects were there at the time of delivery. But this is not onerous. You know, the TV blew up the very next day. It's not hard to prove. As far as the remaining 4 R's is concerned, if the goods are defective within 6 months, the presumption is that goods were defective at the time of delivery. If the consumer has had the goods for more than 6 months, the consumer must prove the goods were defective at the time of delivery. Please note that none of the CRA rights affect the consumer's common law rights. So if I suffer personal injuries because, let's say, my phone I bought blew up in my face, I can claim for medical bills, lost wages when I'm in hospital. That is my claim under the common law. If the new phone costs more from another shop, I can claim that difference in price from the trader. This is just under normal common law rules. Let me tell you about Pendragon against Kuhn. We don't have many cases on the CRA, but this one's a particularly good one, especially the emphasis being on remedies. Let me tell you about it. Pendragon against Kuhn. This case involved a professional breeder who sold an English sheepdog at a reduced price of £1,000. Now, the price was reduced because the dog was the product of an accidental mating. So it was not registered with the Kennel Club, which is UK's largest database for pedigree dogs. The buyer was okay with that because she wanted a pet. She didn't want a show dog. So she didn't need a pedigree dog for breeding. She wanted a pet. A few months later, the dog developed hip problems. The dog needed medical attention. The buyer wrote to the seller saying the dog was not of satisfactory quality. Remember, goods means anything which is tangible and is movable. So dogs is goods under the CRA. So the buyer told the seller that the dog was not of satisfactory quality. The seller offered to take the dog back and refund the purchase price, but the buyer refused. Instead, the dog had a hip replacement, and when the new hip dislocated, there was further surgery. The buyer did have pet insurance, but she still had to pay a large percentage of the bills. The buyer was now suing the seller for breach of Section 9 satisfactory quality, and she was claiming £5,000 as the uninsured vet cost. The judge said, yes, the dog was in breach of Section 9. The price payable for the dog, £1,000, the price was reduced to reflect that the dog was not suitable for breeding purposes. But the price was not reduced for the risk of hip problem. So the dog was not of satisfactory quality. So the court said the buyer did have the right to reject the dog and get a full refund. She might also have been entitled to some damages to reflect her wasted expenses up to that point, which was about £83 at that time. But remember, in the case, the buyer refused to reject. She decided to keep the dog, and she incurred substantial costs trying to repair the dog. Now, under the CRA, we know the buyer has 5 R's: reject, repair, replace, reduce, reject. The buyer did not want to reject, so she was essentially demanding repair. What the judge said was three things. First of all, the right to repair is not the right to carry out the repair. It's a right to have the repair carried out by the trader. It is the trader's choice. Once the consumer requests repair, the trader can choose to repair or replace goods under the CRA. Second thing the judge said was, even if repair was possible, the cost must not be disproportionate to replacement. The notional value of the dog was £1,000. The cost of repair was more than £10,000. This is disproportionate to the remedy of repair. The buyer argued it was reasonable to try to repair the dog because the dog had become her pet. Judge disagreed. The judge said the high medical expenses was out of proportion to the value of the dog. Third thing the judge said was that it was not possible to repair or replace the dog. So the only remedy available to the buyer is a price reduction or the final right to reject. The court allowed the buyer a price rejection up to the full amount paid for the dog because essentially the dog was worthless. The purchase price, if you remember, was £1,000. So she got £1,000 back. The court awarded the buyer damages of £83, which was the vet costs she could have claimed if she had rejected the dog in the first place. Now, if this was a B2B contract, would the buyer's remedy be any different? We know, of course, that if the business buyer does not reject goods, damages would be awarded under Section 53 of the Sale of Goods Act, in other words, under the difference in value test. In other words, the difference between the value of the goods at the time of delivery and the value if they had conformed to the contract. Section 53 does not apply to consumer contracts, of course, but Section 53 reflects the common law position. The CRA does not affect the consumer's common law remedies, of course. So in other words, the common law remedies always are available to the consumer. Section 53 Sale of Goods Act merely reflects the common law position. The calculation under Section 53 difference in value test would have been £1,000 because the value of the dog at the time of delivery would have been zero. So you see, in Pendragon against Kuhn, the outcome for the buyer would have been the same, whether the buyer was a business buyer or a consumer buyer. What this case also goes to show is that dogs are treated just as any other faulty goods. Okay, look at partial rejection. Section 21 is similar to the Sale of Goods Act, Section 35 Big A. I won't bother to go through this. Just note that Section 21 does not apply to commercial units. Let me just make up an example to illustrate what this means. Example, I buy a pair of shoes. Now, if the left shoe is defective, what Section 21 is saying, I can't just reject the left shoe. I need to reject the pair of shoes or not at all, because the pair of shoes forms part of the commercial unit. It's very simple, very easy. Delivery of goods. Section 28 says, unless it is agreed otherwise, the trader must deliver goods without undue delay and within 30 days after the contract. Now, of course, the parties can make time of the essence. So maybe I agreed a deadline with a trader, or maybe the deadline was obvious. So, for example, if I order a birthday cake for delivery next Tuesday, well, obviously time is of the essence. If the trader does not meet the deadline, the consumer can treat the breach as a breach of a condition. So the consumer can terminate the contract, get his money back, and claim damages. Remind you again that the common law remedies are not affected. Look at risk. Section 29, risk is very different to B2B contracts. Under the CRA, goods are at the trader's risk until the goods are in the physical possession of the consumer. So if anything happens to the birthday cake when it was in the delivery van, it is the trader's problem. The trader bears the loss. Now let's look at exemption clauses. The first thing to say is that the common law rules are exactly the same for both B2B and B2C contracts. So we know about incorporation, we know about contra proferentum. So give me 1 second. Right. So those rules that we've already revised, incorporation, contra proferentum, it applies to both B2B and B2C contracts. With B2B, the statutory regulation is under UCTA, Unfair Contract Terms Act. With B2C contracts, the CRA itself contains the provisions. UCTA regulates unreasonable terms. The CRA talks about unfair terms. The CRA regulates not only terms of the contract, but it also regulates consumer notices. A consumer notice means any announcement or communication intended to be read by the consumer. So for instance, you see notices in the shop or notices in the car park. All of these things are terms as far as CRA is concerned. These notices are covered by the unfair regulations. The general rule is this: contract terms and notices are not binding on the consumer if they are unfair. What does unfair mean? Well, section 62 says that a term or a notice is unfair if two things. First, it is contrary to good faith. And secondly, it causes a significant imbalance in the parties' rights and obligations. Unfairness, of course, is to be judged by the nature of the goods or services and the circumstances of the case. Well, so it goes on the contract. Now, section 62 itself lists terms which are automatically unenforceable. This is called the blacklist. Blacklist items are void. Full stop. It doesn't matter if they are fair or not. They are always void. These terms are blacklisted. Section 31 covers goods contracts. What it says is the trader can never exclude liability for satisfactory quality, fitness, description, basically everything we've already said about goods, including delivery and risk. If the trader tries to exclude liability, sorry, it's always void. It's blacklisted. So if the trader restricts compensation payable to less than the price for the goods, it's void, blacklisted. Section 57 covers services contracts. A trader cannot exclude their liability for taking reasonable care and skill, reasonable price, reasonable time. Now, we haven't looked at consumer services yet, but the provisions are virtually the same as those under the 1982 Act. Care, time, price. Well, the point is the trader cannot exclude for care, time, price. The third thing on the blacklist is section 65. The trader can never exclude or restrict negligent liability for death or personal injuries. This is the same under section 2 sub 1 UCTA, exactly the same. Now, I've given you some examples in the handout. Just read that in your own time. There is also a grey list in Schedule 2. Schedule 2 sets out terms which may be unfair. This is known as the grey list. Schedule 2 is non-exhaustive list, so terms on the list are not automatically unfair, but probably they are unfair. And the court will consider the fairness test under section 62. Just note Schedule 2, paragraph 1. This excludes liability for death or personal injury. That's in the grey list. Now, of course, negligent liability is definitely on the blacklist. We know that, negligent liability blacklisted. The grey list more or less repeats it, except it is not restricted to negligent liability. Essentially, it gives the enforcers of the CRA a double chance to get at traders if they try to restrict liability, any liability, for death or personal injury, howsoever caused. Give you an example. If the gym says they are not liable for personal injuries if the customer does not use the equipment as directed, or if the personal trainer is not around. So the gym is not excluding negligent liability, they're just excluding liability if you don't follow their rules about using the equipment. This will fall within the grey list, and the courts will assess if that term is fair or not under section 62. As far as other loss or damage is concerned, in other words, not death or personal injuries, the trader can exclude if it is fair under section 62. This is the same under section 2 sub 2 Unfair Contract Terms Act. The grey list terms are fairly obvious. I mean, if the contract term says that the trader can unilaterally vary the terms and the consumer cannot disagree, then this is likely to be unfair. So, for instance, if the trader changes my gym membership fee from $200 to $1,000 per month without any warning, and the consumer cannot get out of that membership, this will fall within the grey list. I've listed some examples in the handout. Again, please read in your own time. Just one case. Bairstow Eves against Smith. The estate agency fee in the T's and C's was 1.5% commission if it was paid within 10 days. If it was not paid within 10 days, the T's and C's said double commission was payable, in others 3%. This was held to be unfair. Now, as I said, if the term is not on the grey list, it does not mean it is fair. Schedule 2 is only an indicative list. Courts can always assess for fairness. In fact, the court has a positive duty to consider the fairness test. Even if the trader nor the consumer complain about the term, the court has a duty to consider the fairness test. Section 68 sets out the transparency test. Section 68 just says all terms must be transparent. In other words, all terms must be in plain, intelligible language. And if it is in writing, it must be legible, not in tiny writing. The idea is that the consumer must be able to understand the practical significance. The CRA just wants to make sure the consumer makes an informed choice. Now, even if the term is transparent, it's plain, intelligible language, it's still unfair if the consumer has not been given an opportunity to examine. So, for instance, if the consumer is handed a 500-page document right at the cash till, well, I'm standing in the shop and there's a long queue. So the point about that is probably the terms will be unfair, because even if it's easily readable, it's unfair when I can't have an opportunity to read it. Now, the transparency test and the fairness test are two separate tests, but they operate side by side, because the fairness test requires good faith. If the transparency test is satisfied, in other words, the T's and C's are very clear, then it is more likely that the trader acted in good faith. As I said, courts will always assess terms under the fairness test. It does not matter if it is in the grey list or not. There is one exception to that rule. This is the core exemption. Under Section 64, courts will not assess if a term is fair or not if that term concerns the main subject matter, usually the goods or the services being bought, or the price payable. But note that the core exemption only applies if the term is TAP. TAP is transparent and prominent. Now, we know what transparent means. It means the terms must be in plain, intelligible language. Well, what does prominent mean? Well, Section 64 says a term is prominent if it is brought to the average consumer's attention in such a way that the consumer is aware of the term. Now, average consumer, that's a European concept. An average consumer is someone who is reasonably well informed and observant. Of course, this always depends on the nature and context of the transaction. So, for instance, I want to join a cheap gym. Well, my attention level is not going to be the same as someone wanting to join an expensive, exclusive club. Okay? The core exemption only applies if the term is TAP, transparent and prominent. If the term is not TAP, the term can be assessed for fairness. This rectifies old law, OFT against Abbey National. Facts don't matter at all. Let me just make up an example to show you what we're looking at, the core exemption. Let's say I sign up to a mobile phone contract for $1,000 a month. I then find out my next door neighbor, she got the same package from the same trader for $200 a month. Can I argue my deal is unfair? Well, if the price, inclusive of texts and minutes, if the price was clearly explained to me when the contract was made and they were TAP, transparent and prominent, the answer is no. I cannot complain. This falls under the core exemption. I just made a bad bargain. It's my problem. I mean, it's similar to me selling you my brand new Mercedes for 10 cents, or I sell you my pen for $1 million. The courts won't interfere. You and I can agree whatever price we want. If a term falls in the grey list, the term is always accessible to fairness test, even if it is transparent and prominent. Okay, so what's the consequence of unfairness? Well, if a term is unfair, that term is not binding on the consumer. This does not mean the whole contract is unenforceable. No, I just mean those terms are unenforceable. If there is any ambiguity in the meaning of the term, contra profferentem is applied. Note, the court will not vary an unfair term. So, for instance, if the trader says 25% is the interest rate, well, if let's say 25% interest rate is unfair, the court will not reduce it down to, say, 5% to make it fair. Otherwise, as you can imagine, traders might use an unfair term knowing that the courts would adjust anyway, that they would reduce the interest rates anyway. All right, well, we better take a 10-minute break. All right, we'll take a 10-minute break now. Okay. Okay, let's move on to consumer services contracts. Now, this is certainly not going to take us very long to complete because we've already studied the Supply of Goods and Services Act, which applies to B2B contracts. Service contracts under the CRA are really, really similar. So it's not going to take us very long to cover it. In fact, I reckon I can cover it in 5 minutes. What is a service contract anyway? Well, Section 48 of the CRA says a service contract is a contract where a trader supplies service to a consumer. Interestingly enough, there is no definition of a service. Presumably, if the trader does not supply goods, he does not supply digital content, then he must be supplying a service. The CRA applies to mixed contracts. For example, if you get a car serviced where parts are fixed, if the goods part of the service is defective, then you look at the goods, rights and remedies. We've just seen those. We know all about satisfactory quality, fitness for purpose. So the goods is faulty. That's what we've already looked at. If the service part of the contract is defective, then you look at the service, rights and remedies. That's what we're looking at now, the service bit. But as I say, it's very similar to the 1982 Act. So let's start off with care and skill, Section 49. Well, this is the same as Section 13 of the 1982 Act. The service must be carried out with reasonable care and skill. Use the same cases, please. Bolam against Freeland Hospital, Nettleship against Western. Use the same cases. Pre-contract info, Section 50. Now, this is new, but it's not tough. All Section 50 says is that if the trader tells the consumer something about the service or something about himself, that something needs to be true. So if the trader says he is a member of a trade association or he has a particular qualification, then that information must be true. Price, Section 51. This is the same as under Section 15 of the 1982 Act. If the price is not fixed under the contract, the consumer pays a reasonable price. Same thing we said before. I don't need to say anything more. Time, Section 52. This is the same as Section 14 of the 1982 Act. The trader must complete the work within a reasonable time. Use the same cases as we did before. So this is nothing new to us. Different section number, that's all. Remedies. Well, the consumer this time only has 2 R's. 2 remedies, 2 R's, repeat, reduce. Repeat performance, let's look at that first. If the service is not provided with reasonable care and skill, in other words, a breach of Section 49, the consumer can demand that service is done again. This is at no cost to the consumer. This is similar to buying defective goods. The consumer can demand repair or replace. With a service, the consumer can demand repeat performance. If the consumer does demand repeat performance, the trader must repeat performance without reasonable time, without causing significant inconvenience to the consumer. Of course, it is the trader who pays all the costs of repeat performance. The second remedy for the consumer is price reduction. The consumer is not automatically entitled to a price reduction or the money back. Only if repeat performance is not possible. So for instance, if a photographer was contracted to take photographs at a wedding and he did a really rubbish job, the wedding has been and gone. It was last week. It's impossible to put the service right. So the only remedy is a price reduction. So the other way of getting a price reduction is if repeat performance is not possible, or it is not possible to repeat performance within a reasonable time. So for instance, if a builder says he's very, very busy and he can't repaint for 3 months, or maybe repeat performance is not possible without causing significant inconvenience to the consumer. So for instance, maybe the builder has already repainted the house, but the workmanship is still totally rubbish. Well, it's very inconvenient to redo. If that's the case, then we can ask for a price reduction. Price reduction could be up to the full amount, but the trader can take into account the benefit that the consumer has had from the service. If the repaint is totally rubbish, I'll probably get a full refund because I will need to employ another builder to start from scratch. The refund must be made without undue delay, at the latest within 14 days of agreeing that the consumer is entitled to the price reduction. For breach of Section 52 reasonable time, the consumer's right is price reduction only. You can't have repeat performance because the builder has already done the work. It just took longer, that's all. What is important to note again is that these remedies do not affect the common law remedies. The consumer does not have to ask the trader to repeat performance. Maybe it was done so badly that I lost faith in the builder. I prefer to get someone else to do the job and claim damages from the first builder under the common law. Or maybe it's impractical. I mean, the London garage serviced my car, but it breaks down in Manchester. Well, I can get the car fixed in Manchester and I can claim that cost from my London garage. So that's what we need to know about consumer contracts. Okay, let me just have a look. There's a question. Sorry, there are a couple of questions on the screen. Are nemodat and exemption clauses the only topics which may appear as essay questions in our exam? The answer is definitely not correct. Nemodat questions have 50-50 chance, 50-50, whether they are essays or problem questions. 50-50 chance, nemodat. Exemption clauses, exactly the same, 50-50. Sometimes problem, sometimes essays. At the revision course, we will indicate to you then whether you're going to get an essay or a problem. But until then, we haven't written the exam papers yet, so we can't tell you. All right, but 50-50 chance. There are some topics, I mean, you're right. There are some topics that are 99% of the chance it will be problem questions. I'll talk about it a little bit later on anyway, but yeah, nemodat and exemption clauses, 50-50 chance. Sometimes essay, sometimes problem. The next one is, for exam purposes, should we focus on studying B2B problem questions, and the only chance for CRA to come up would be writing for an introduction to the problem question, or there's a chance comparative, yes. Yeah, problem questions, yeah, I would say problem questions will be B2B. Let me think, the last time we set a CRA problem question. Not for as long as I can remember. B2B problem question, yes. But B2C, there will be comparative essay questions. We could, for instance, ask you, we could ask you all sorts of things to compare. For instance, we might say, does the Consumer Rights Act, is that a huge improvement on B2B contracts? So is the protection afforded to the consumer, far superior than the protection afforded to the business buyer? Yeah, we could say that. Or we could narrow it down a little bit. We could say exemption clauses. How, what is the comparison between the B2B exemption clauses and B2C exemption? What is the regulation of the two? Now, remember, the common law is the same for both, right? So that's no different. But obviously, one is under UPTA, the other one is under CRA. But I think if it's a problem question, chances are, yeah, I think it's safe to say, chances are we're really looking at sections 13 and 14 of the Sale of Goods Act. We're talking about the 1982 Act for B2B, for supply of goods and services. But so that's why, you see, it doesn't take me very long to cover consumer contracts. It's not because it's not important, but it's because it's virtually the same. So, of course, when you ask to compare and contrast, well, there's only so much compare and contrast you can do. All right, so we've covered it all anyway. So other topics may only appear as problem questions. No, that's not true at all. There are some topics which are usually problem questions. But whether they turn up, but some questions will be 50-50 chance, sometimes essay, sometimes problem. So you can't say other topics only appear as problem questions. No, not really. Only, 99% sometimes, but not all the topics. All right. So I know you're all keen to know, but we haven't written the exam paper, so how can we tell you what it is? But usually, all right, I mean, to give you a clue, I suppose, usually transfer of property and risk, problem question. Section 13 and 14 of the Sale of Goods Act, description, quality, fitness, usually problem. 1982 Supply of Goods and Services Act, usually problem. But memo dat, exemption clauses, 50-50 chance. Could be problem, could be essay. Could be problem, could be essay. All right, so there are other topics as well, but these ones are, so 3, I've already given you a clue. It's fairly usual to have problem questions, but the others you can't tell. They can be essays, all right? All right. Now, let's look at financing of transactions. Okay, let's look at financing of transactions. Now, we'll start by looking at bills of exchange. The reason why businesses enter into transactions is to make money. So being paid is number one. Cash is king, but it's also not practical. Buyers don't walk around with £10 million in cash. Sure, we can do e-transfer, but in the real world, the buyer does not have money. He needs to sell goods himself before he can pay the seller. So the buyer needs a credit period. The seller doesn't mind allowing a credit period, but the seller wants to be sure he gets paid. That's where negotiable instruments come in. We will concentrate on the bill of exchange. Bill of exchange is one type of negotiable instrument. One type of bill of exchange is the check. The chart that's on the screen now just shows the types of personal property. We looked at this chart before. Goods shows us in possession. They are in possession because you can physically hold a bunch of bananas. It's tangible. It's in your physical possession. What we're looking at now is shows us in action, intangible property. You can't physically hold it, but you can sell it. For instance, intellectual property rights or debts represented by negotiable instruments. The bill of exchange is one type of negotiable instrument. What's special about negotiable instruments is this. The first thing to say is that the bill of exchange is a physical piece of paper. This physical piece of paper is virtually cash. The bank will pay when it matures. The bank will pay on the date fixed for payment. So the seller is assured of payment. You see, the seller himself needs to buy goods from someone else. Because the negotiable instrument is virtually cash, the seller can buy from his supplier against the security of the instrument. The other side of the coin is that the buyer gets his credit period. The second fantastic thing about negotiable instruments is that the debt obligation is completely separate from and independent of the underlying sales contract. So if the buyer and the seller dispute something about quality or something about the goods, the dispute does not affect the debt obligation in the instrument. Even if the buyer has the right to reject the entire consignment of goods because they are all defective, the instrument is not affected at all. Even if there is total failure of consideration on the underlying sales contract, the payment obligation continues to exist. The whole point about the negotiable instrument is that the seller is assured of payment. So any dispute between the seller and the buyer does not affect the payment obligation. The bill of exchange just carries on. So once the bill of exchange is set up, it is totally independent. The third amazing thing about the bill of exchange is that it can be transferred by delivery alone, or by delivery and endorsement. Endorsement, now the signing it on the back. And the transfer of the negotiable instrument, that operates as a transfer of title to the rights in it, if it is done with that intention. Nothing else is required. There is no need to give notice to the debtor, in other words, the person who owes money. So there is no need to give notice to the buyer that the seller is transferring the rights in the bill of exchange. This is an exception to the doctrine of privity. Finally, the holder in due course takes free from any defects in title of the transferor. Now, you and I studied the Memo-Dat rules. You know that you cannot give what you haven't got. There are lots of exceptions to protect the third-party bona fide purchaser for value. Negotiable instrument is a major exception to the Memo-Dat rule. You see, the bona fide purchaser for value is what we call the bona fide transferee for value. We call him the holder in due course. This guy, the holder in due course, can acquire better title than his transferor. It's a major exception to the Memo-Dat rule. The bill of exchange is also a good illustration of how commercial law tries to protect third parties. Certainty has always been rule number one for the business community. If the negotiable instrument satisfies Section 3 of the BEA, then everyone knows where they stand. The bill of exchange is virtually cash, and the bill of exchange will be honoured. Courts will not interfere. Courts have always recognised commercial practice. The bill of exchange is a good example to illustrate this point. The bill of exchange arose because the courts recognised the use of negotiable instruments in commerce. You see, in the olden days, the law did not recognise the transfer of debt. That's why merchants wrote a debt on a piece of paper. Bingo! The law now recognises the transfer of a piece of paper. There are lots of different types of negotiable instruments, but essentially it boils down to two types. An order to pay, for instance, bills of exchange and cheques. The second type is a promise to pay. Examples would be promissory note, which is an IOU. Another example is a certificate of deposit. This is essentially a bank's IOU. The bank gives a receipt for money received and promises to repay plus interest on a certain date. Our syllabus concentrates on the bill of exchange. We will mention checks, take us about 1 minute, but our syllabus is mainly on the bill of exchange. So what is a bill of exchange? Well, the law is governed by the BEA, the Bills of Exchange Act 1882. In a nutshell, the bill of exchange is an order to pay, an order by one person to another to make payment to a third party or to a bearer. So I order you to pay the third party. The third party can transfer the bill of exchange to third party number 2, transfer it to third party number 3, etc. The situation we are looking at here is this. I agree to sell goods to the buyer for £1 million. The buyer wants 90 days credit. I agree as long as the buyer gives me a bill of exchange drawn on a reputable bank. So I know I will get paid in 90 days. The bill of exchange is literally a piece of paper. The buyer writes his instructions on a piece of paper, telling the bank to pay me in 90 days. The buyer gives this piece of paper to me. Now, of course, this piece of paper is not worth very much. It's just a piece of paper. I need to get the bank involved. Now, the bank only becomes a party when the bank accepts the bill. In other words, the bank signs it to say the bank will pay me in 90 days. So what I do is I get the piece of paper from you. I need to present the piece of paper to the bank for acceptance. If the bank accepts, the bank signs. When the bank signs, the bank undertakes to pay me in 90 days later. 90 days later, I present the bill to the bank and the bank pays. If I don't want to wait 90 days because actually I need money now, I can sell this bill, this piece of paper, to someone else. The bank will pay whoever is holding this bill. Section 3 of the BEA sets out conditions which must be satisfied before a bill of exchange is a bill of exchange. Section 3 is very strict. If the conditions are not satisfied, this piece of paper is not a bill of exchange. But before we get into the Section 3 conditions, let's deal with some terminology. Parties to the bill of exchange are the drawer. The drawer is usually the buyer, the person who writes or draws the check. That's why he's called the drawer, the buyer, the person who writes or draws the check. The drawee, this is usually the bank, the person to whom the instructions are given. The drawee is usually the bank, but it doesn't have to be a bank, it can be somebody else, but usually it's a bank. The payee, this is usually the seller, the person who gets paid. The acceptor, this is the drawee, which, as I say, is usually the bank. So when the drawee accepts the bill, that person becomes the acceptor, the person who accepts the obligation to pay. The holder, this is the person who is physically holding the bill. Essentially, there are 7 conditions which need to be satisfied before a bill of exchange is a bill of exchange under the 1882 Act. The first condition is that the order must be an unconditional order. Well, it must be an order for a start. In other words, I order you to make payment to X. It must be unconditional. In other words, there must be no conditions. The buyer cannot say to the bank, pay if I have sufficient funds in my account. That is not satisfied under Section 3. Second condition, the unconditional order must be in writing. Now, there is no standard form. In fact, the Bill of Exchange Act the Bill of Exchange doesn't even have to be on paper. In fact, there's a very famous story about a check written on the side of a cow. Inland Revenue against Haddock. Now, it's a made-up case. It comes from a book. But in this made-up case, the Inland Revenue was demanding tax for a man called Haddock. Haddock wrote his check in red ink on the side of a white cow. The Inland Revenue argued this was not a check. The court held, yes, it is a check. The law does not say that the check must be written on paper. So a check written on a cow was okay. Now, although this is a made-up story, courts have referred to it. It's a bit like Sherlock Holmes. I mean, Sherlock Holmes is not a real person. So as far as going by the BE is concerned, when someone wins the lottery, I mean, you often see, don't you, a huge presentation check. Sometimes just massive. There is no reason why a bank won't accept that huge check. I'm not sure, however, if email instructions count as in writing. Probably not. That's because the BEA refers to a holder of the bill of exchange. This contemplates someone physically holding it. You see, the bill of exchange is like money. It's like a $100 note. If I scan a $100 note and I email it to you, you don't get good title to $100 whilst I am physically holding it because I can still spend it. So if I scan the bill of exchange and I email it to you, not much use. Now, the BEA was amended about 10 years ago. Section 89A does allow banks to accept electronic images. So I can take a picture of a check using my phone and I can send it to the bank through the mobile app. The picture of the check is treated as a paper check, but this is only for the purposes of presentation for payment. It does not apply to the creation of rights and obligations of the instrument itself. So when I make an online transfer, it is definitely not a bill of exchange. We're looking at the Section 3 conditions. The first condition is that the bill of exchange must be in writing. It does not have to be on paper, but email instructions don't count. Third condition, the bill of exchange must be addressed by one person to another. So the drawer and the drawee must be different people. Otherwise, you see, it would be an order to oneself. I order myself to pay X in 6 months' time. Well, that's a waste of time, isn't it? Now, if the drawer and drawee is the same person, it's not a bill of exchange. Mind you, the drawer and the payee can be the same person. It is a bill of exchange. So I write out a check in my name. I order you to pay me. That's what we used to do before ATMs were available. Because if you wanted to withdraw cash from a bank, you'd go to the bank, you'd write a check payable to self. That's how you used to get cash. The fourth, Section 3 condition is the bill of exchange must be signed by the person giving it. The drawer must sign the bill of exchange. Now, there's no definition of signature though. If an agent is signing, he must say that he signs as agent. Otherwise, he will be personally liable. Now, if the signature is forged or unauthorized, then the signature is wholly inoperative. It is not a valid bill of exchange. More on this bit a bit later on. Fifth condition is the bill of exchange must be payable on demand or at a fixed or future time. Now, Section 10 says a bill is payable on demand in 3 ways. It is payable on demand if the bill, firstly, expressly says it is payable on demand, or it says it is payable at sight. At sight means payable when presented to the bank for payment. Or, thirdly, it does not state a time for payment. Now, instead of being payable on demand, the bill of exchange could be payable at a fixed or future time. Now, pay at a fixed or future time is pretty obvious. Pay on the 1st of February. That's obvious. But Section 11 goes on to say, and I think this is on page 84 of the handout, but Section 11 goes on to say it includes pay at a fixed time after the occurrence of a specified event, which is certain to happen, though when the event happens is uncertain. So Section 11 goes on to say it includes pay at a fixed period after the occurrence of a specified event which is certain to happen, though when the event happens is uncertain. What does that mean? Well, essentially, it is the date of payment that is crucial. If the date is unclear, it is not a bill of exchange. It's easier, I think, if I give you some made-up examples. They are on the screen now. So example, if the bill says pay on or before the 1st of January 2024, this is not a bill of exchange because the bank has the option of paying before the 1st of January 2024. The date of payment is crucial, as I said. So if the bank can pay earlier, then this 5th condition is not satisfied. Example, if the bill says pay 90 days of acceptance, this is also not a bill of exchange. Acceptance is not certain. The bank might refuse to accept. Sure, I know the bank will be in breach, but the bank can still refuse to accept. So that event is uncertain. Compare if the bill says pay 90 days of sight. Ah, yes, this will be a bill of exchange. The date of payment is certain. Now, although we don't know when the holder is going to present for payment, but the date of payment is clear. 90 days after sight. In other words, 90 days after the holder presents the bill for payment. Sight is when you are presenting it to the bank. That's what we mean, right? So when you present it to the bank, then the bank will pay 90 days after the bank sees it, has sight of it. Note, the date on the bill itself is not important. It is the date of payment that is important. That's why, you see, a check can be undated or it can be post-dated. It does not matter. We're looking at the Section 3 conditions. A bill is only a bill of exchange if 7 conditions are satisfied. The 6th condition, the bill must be payable to a named person or to bearer. Now, a named person, that's pretty obvious. There is no need, of course, to give an exact name. As long as the person is reasonably identifiable, that's good enough. Bearer is the person in physical possession of the bill. I have some examples on the screen. Pay the Director of Finance HKU. Okay, This sixth condition is satisfied. Pay cash or order. This is not a bill of exchange. It needs to be payable to a named person or bearer. Cash is not a person. Example, pay cash or bearer. This is okay because it is payable to bearer. Pay Joe Bloggs or bearer. Yes, this is okay. Pay Joe Bloggs. This is okay. In practice, it is usual to add or order, but it is not necessary because Section 8 says a bill made payable to a named person is payable to that person's order anyway. Note Section 7. Section 7 says, if a payee is fictitious or non-existent, the bill is treated as payable to the bearer. More on this later. The seventh condition under Section 3 is that the amount to be paid must be certain. It can be in any currency, that's fine. Now, the sum is certain even if interest is charged or the amount is paid by installments. Now, if Section 3 conditions are not satisfied, the bill is incomplete. It's what we call an inchoate instrument. For instance, a blank check. Now, it's not always fatal because the Act does allow defects to be cured. Section 20 gives authority to the person in possession to rectify defects. So that's why you can correct the name of the payee or the date of the drawee's acceptance. Rectification must be done within reasonable time and in accordance with the authority given in order for it to be enforceable against the original parties. There is actually one exception to that rule. A holder in due course can enforce the bill against the original parties, even if rectification is not done within a reasonable time, nor in accordance with the authority. You see, the holder in due course is a very special person. We'll look at him a bit later on. He can enforce it. Now, we said a bill of exchange is a credit facility. The buyer is paying in the future. So the seller has to wait to be paid. But the beauty of bill of exchange is that they are transferable. So if the seller needs cash now, the seller can transfer it. He can sell the bill of exchange. Usually, the seller gets discounted cash. Let's say I have a bill of exchange for $10,000, payable next year, the 1st of February 2025. I will sell it to you now for $9,000. So I am getting discounted cash. You transfer it to A can transfer it to B, etc. This transfer is called negotiate. So the seller negotiates it to A, who negotiates to B, and so forth. The great thing is no one needs to tell the original buyer or his bank. There is no need to give the original drawer, that's the buyer, or the original drawee, that's the bank, notice at all. They will be liable on it. This is an exception to the doctrine of privity. How to transfer? In other words, how do you negotiate this? Well, that depends on the type of bill. There is the order bill and the bearer bill. An order bill is where the bill of exchange is made payable to a named person or to his order. To transfer, all the seller has to do is to sign at the back. We call this signing endorsing. So all the seller has to do is to endorse it. In other words, just sign it at the back and the seller just delivers the bill. If I name the person I am giving the bill to, it's called a special endorsement. If I just sign it and I do not put anyone's name on it, it's a blank endorsement. If it's a blank endorsement, the bill becomes a bearer bill. Now, with a bearer bill, there's no need to sign at all. The bill passes on delivery. Here you are, here it is. So, and possession can be actual possession or constructive possession. So I might give you the keys to my safe. That's where I keep my bills. So if I give you the keys to my safe, that is, I'm transferring the rights to you. Or maybe if the payee or the last endorsement is a fictitious or non-existent person, then again, the bill passes on delivery. Now, I mentioned section 7 before. If the payee is fictitious or non-existent, the bill is treated as a bearer bill. No need for the facts of the case, but the leading authority is Bank of England against Vagliano Brothers. The House of Lords said it didn't matter whether the payee forged the name of a real person or he gave a completely made-up name. Either way, the payee is fictitious. Now, we don't need to go into the facts of Vinden against Hughes, but the case suggests that the drawer's attention is important. The drawer's intention is important as to whether or not the payee is fictitious. If the drawer intends for this payee to receive payment, then that payee is not fictitious. You see, in Vinden, the case itself, a fraudulent employee, he used existing customer names on the bill. The drawer, that's the employer, the drawer thought they owed their customers a refund. So when the employer signed the bills, the employer, the drawer, intended named existing customers to receive the payment. So the court said the payees were not fictitious. So the bills were not bearer bills. They were order bills. There are difficulties with this. Supposing the fraudulent employee, supposing he used made-up names as payees, in other words, non-existing customers. Let's say the check says, pay Harry Potter. Surely the drawer did not intend Harry Potter to be paid. So the payee is fictitious. If payee is fictitious, then the bill would be a bearer bill, and the bank must pay whoever shows them the physical piece of paper. So it's always a problem whenever a rogue is involved. Someone has to bear the loss, either the innocent drawer, the person who draws the check, or the innocent third party. Now, if the fraudulent employee uses an existing customer name, the bill is an order bill. The employer wins. The employer gets the money back. If the fraudulent employee uses a crazy name like Lord Voldemort, then the bill is a bearer bill and the employer loses out. So it just depends on what name the fraudulent employee writes for the payee. Sounds a bit crazy, but that's how it stands. Section 7 says it is a bearer bill if the payee is fictitious or non-existent person. Now, actually, is there a difference anyway between fictitious and non-existent? Well, not really. There's no practical difference because Section 7 treats both the same way. I mean, I think the difference is that a non-existent payee must necessarily be fictitious. But the opposite is not true. I mean, a fictitious payee is not necessarily non-existent. I mean, look, let me give you an example. I name my mother as payee. My mother exists, but she's got nothing to do with this bill. She knows nothing about it. So my mother is a fictitious payee. But suppose I name Joe Bloggs as a payee. It's a name I just pick out of the air, Joe Bloggs. It's a made-up name. It's fictitious. But it does not mean Joe Bloggs is non-existent, because I bet you there are hundreds of people called Joe Bloggs somewhere in the world. So just because a name is fictitious, it does not mean the person does not exist. Now look, don't spend too much time thinking about this. I mean, whether a payee is fictitious or non-existent, it doesn't matter, because Section 7 treats them the same. In fact, just one final point, it is possible actually for a payee to be both fictitious and non-existent. Example, pay Sherlock Holmes, pay Lord Voldemort. They are both fictitious and non-existent. Okay, let's move on. So who has the right to enforce payment under the Bill of Exchange? The answer is the holder. Now, there are three types of holder: mere holder, holder for value, holder in due course. A mere holder has the least rights. Holder in due course has the best rights. Let's look at each in turn. Mere holder. The mere holder is a person who is not a holder for value and not a holder in due course. Not very helpful, I know, but you see, a mere holder has very limited rights. That's because he is not someone who has given consideration for the bill. So although he can present the bill for payment, or he can transfer the bill by endorsing it, by signing it, he can be challenged on grounds of failure of consideration. Bill of exchange, you see, is a type of contract. So consideration must move from the promisee. So if you have not given consideration, you cannot enforce a promise. So actually being a mere holder is of no use really at all. The second type of holder is the holder for value. Now, what does for value mean? Well, for a start, everyone who signs the Bill of Exchange is deemed to have given value for it. That is Section 30, sub 1. The burden of proof is on the other party to prove otherwise. Now, value can be given in three ways under Section 27. Now, the normal contract rules are a little bit relaxed here, because the first way that value can be given under Section 27, the first way is under normal contract rules about consideration. Consideration need not be adequate. It only needs to be sufficient. So 3 chocolate wrappers is fine. Pay £1 rent to live in a huge mansion, that's fine. It just needs to be something. So normal contract consideration rules apply. Second way to give value is discharge of an existing debt or liability. Well, this is definitely not normal contract rules. Usually, I mean, you and I know past consideration is not sufficient consideration. But value has a wider meaning under the BEA. Example, you lend me money. Then I say, I give you a bill of exchange to discharge my debt. You agree. I don't give you the bill of exchange. Under normal contract law, can you sue me? No, the answer is no, because you have not given me consideration for my promise to give you a bill of exchange. You lent me money yesterday. That's past consideration. Where is your consideration for the bill of exchange? But you see, under Section 27 BEA, it's okay. Discharge of an existing debt is giving sufficient value. The third way to give value is someone in the chain has given value. Wow! I mean, you don't even need to give value. If someone before you gave value, you are deemed to have given value. The case authority is Diamond against Graham. No need for the facts. It's easier to explain if I just use a made-up example. So let's say I sell buyer goods. The buyer gives me a bill which the bank has accepted. I transfer the bill to you as a gift. You present it to the bank. The bank does not pay. Now, you can't sue me because I gave you the bill as a freebie, it was a gift, there was no consideration. But Section 27 allows you to sue the buyer. You didn't give consideration to anyone because it was a gift. But as long as someone in the chain gave consideration, that is sufficient. I gave consideration because I sold the goods to the buyer. So you, as holder for value, can sue the buyer. As you can see, normal contract rules are relaxed. So the holder for value has valuable rights, but not as good as the holder in due course. The holder for value has no better rights than his transferor. He takes the bill subject to the defects in title of those in the chain. Let's look at the holder in due course. Now, the holder in due course is a very special holder. The holder in due course is equivalent to the bona fide purchaser for value in Nemo Dat. If the bona fide purchaser falls within the Nemo Dat exceptions, he gets good title, even if the rogue does not have title. Similar thing with a holder in due course. He gets good title, even if someone in the chain is a rogue or there was a total failure of consideration. The only limitation on the holder in due course rights is where the signature has been forged or is otherwise ineffective, maybe because, for instance, that the signature was obtained under duress. So who is a holder in due course? Well, for a start, every holder is prima facie a holder in due course. That's under Section 30, sub 2. So we need to look at Section 29. Section 29 sets out the 5 conditions that need to be satisfied before a holder is a holder in due course. First of all, the holder must have taken a bill. Note that the original payee cannot be a holder in due course. That's because Section 29 says the holder must have taken the bill. In other words, he must have got it by transfer or negotiation. So the original payee got it because he was the original party. He is a holder, but he cannot be a holder in due course. It was not negotiated to him. This was confirmed in Jones against Waring and Gillow. No need for the facts. I've put the quote in the handout. Please read that in your own time. Second of the Section 29 conditions, the bill must be complete and regular on the face. On the face means front and back. Now, we're talking about looking at a bill to see if there's anything weird or suspicious about it. You see, in Arab Bank against Ross, the payee was a Palestine firm. The bill stated that the payee name as Fathi and Faisal Nabulsi Company. One partner endorsed it. One partner signed the bill as Fathi and Faisal Nabulsi. He omitted the word company. The bill was endorsed to the Arab Bank. Question for the court was whether the bank was a holder in due course. The answer to that depended on whether the bill was complete and regular on the face. The Court of Appeal said the bill was not complete and regular, so the bank was not a holder in due course. There was expert evidence in court that the banks will not accept an endorsement if the name is not the same, even if only the word company was omitted. Maybe, you see, company has a vital significance in Palestine. It's like limited in England. It signifies a different legal entity. Joe Bloggs and Joe Bloggs Limited are two different things. Or maybe company shows more than two partners are involved. So the bill, the court said, was not regular. So the bank was not a holder in due course. The bank can claim as holders for value, yes, but they're not the special type in due course. The rationale, you see, behind these rules, these strict rules, is that the holder in due course, it's like a bona fide purchaser for value. He must be bona fides. He must be beyond suspicion. So the payee's name on the front of the bill is different to how he signs or endorses at the back, then the holder ought to have suspected that something was wrong. The third, Section 29 requirement is that the bill must not be overdue. A bill is overdue if it is not presented for payment by the date specified. The fourth, Section 29 requirement is that the holder must take the bill without notice and in good faith. Without notice of what? Well, it means without notice that the bill was previously dishonored. Notice means actual notice. But notice, of course, is closely linked to good faith. Now, Section 90 defines good faith as whenever a holder is honest, whether or not negligent. Now, this is very, very similar to Section 61 definition of honesty. Now, the case authority is Jones against Gordon. To avoid creditors, bills which were worth £1,700 were sold to the holder for £200. The House of Lords said the holder was not bona fides. He is deemed to have known of the fraud. He cannot take the bills free of defects. He had deliberately turned a blind eye. We're looking at the holder in due course, Section 29 conditions. We said the holder must have taken the bill. The bill must be complete and regular, must not be overdue, and the bill was taken without notice and in good faith. The fifth requirement is that the holder must have taken the bill for value. Now, we looked at the holder for value, didn't we? I mean, under Section 27, the rules are very relaxed. We said, oh, there are three ways value can be given. First, where consideration was provided. Second, where the bill was given to clear an existing debt. Thirdly, is that someone else down the chain gave value. In fact, the holder doesn't even have to give value himself. As long as someone before him gave value, that's already okay. Very relaxed. An interesting question is this. If a holder can give value, can a holder for value under Section 27 also mean they take the bill for value under Section 29? Because if the answer is yes, then the holder becomes the holder in due course. The answer is actually, we're just not sure. There are arguments either way. Some people say, yes, he becomes a holder in due course because value is value after all. So, and there are two cases. I mean, I don't think these case names are important. I've put the case names in your handout anyway. But as I say, there are arguments against this. Some say no, the holder for value does not become a holder in due course. That's because the literal interpretation of Section 9 says the holder must take the bill in good faith and for value. Seems to suggest good faith and giving value, they go hand in hand. So if you want to be a holder in due course, you must yourself personally give value. We're not sure, actually. Probably preferred is no. Leading academics like Professor Good and Ewan McKendrick, they think no. The holder for value does not become a holder in due course unless some value is given. Once a holder is a holder in due course, Anyone after him has all the rights of a holder in due course. In other words, they take free from any defects of title of prior parties, and they can enforce the bill against all parties as long as he does not actually get involved with previous fraud or illegality. All right, well, let's stop. We haven't got long to finish this, but let's take a 10-minute break now anyway. All right, let's take a 10-minute break. Question on the screen says, in the exam, under which topic will cover seller's remedies? Well, seller's remedies is so brief, isn't it? It's when you were asked to advise the parties. So when you ask to advise the parties, there's a seller involved, then you advise the seller as well as the buyer. Because if the buyer is refusing to accept because the buyer has changed his mind, he doesn't want to buy it after all, then you advise the other party, the seller, to say, actually, you can now sue for damages for non-acceptance under Section 50. Okay? All right. Now, we're talking about the Bill of Exchange. Now, the Bill of Exchange creates contractual liabilities, but the drawer, acceptor, and the endorser are only liable if three conditions are satisfied. Firstly, they have the capacity to contract. Now, this has the same meaning as contract law. So if I am a minor, I do not have the capacity to contract. So I am not bound by the promise on a bill. Everyone else is still bound, just not me, because I don't have the capacity to contract. The second condition is that the bill must be delivered to be complete and irrevocable. Delivery can be actual or constructive. The third condition is that the bill must be signed. Now, the signature is very important. So if you don't sign the bill, you cannot be liable on it. But what if the signature is forged or unauthorized? Well, forgery is a crime. A forged document is an illegal document and treated as a nullity. In the same way, an unauthorized signature is also a nullity. It does not matter whether the signature is forged or unauthorized. The effect is the same. Section 24 says a forged or unauthorized signature is wholly ineffective. So title cannot pass. One exception, estoppel. If the victim of the forgery represents that the signature is genuine, intending the other party to rely on it, and the other party did rely, he is estopped from saying that the bill is forged. The case authority is Greenwood against Martin's Bank. What happened here was the wife forged her husband's signature on checks and cashed them. The husband found out. The wife said she needed the money to help her sister with some litigation. The wife persuaded him not to tell the bank. The husband then discovered that the wife had lied to him. She was not using the money to help her sister. He threatened to tell the bank about the forgery. The wife committed suicide. She shot herself. The husband sued the bank for the money back. He said the checks were forged signatures. The House of Lords said the husband was estopped from denying that the checks were genuine, not forgeries. Mere silence, of course, does not usually amount to representation, as you know. But here, the husband's silence was deliberate. Husband had a duty to disclose. This amounts to a representation. The bank had acted to its detriment because it was too late to sue the wife. She was dead. This is often known as the Greenwood duty. The general rule is this. Once a party signs the bill, he is liable on it. But if the signature is forged or unauthorized, Section 24 says the signature is wholly ineffective. Title cannot pass. This is a defense even against the holder in due course. So the holder in due course has no rights against parties prior to the forged signature. So if you look at the diagram on screen, let's say E forged the signature on the bill. So the bill is useless, but E transfers it to F. F can sue E, of course, only if you can find him, but F cannot sue anyone before E, not even if F is a holder in due course. Forgery has always caused problems, as you know. What about bills payable to bearer? Well, there's no need to sign bearer bills anyway. We've just said that the general rule is that a party is only liable on it if he signs the bill. No one signs the bill, the bearer bill. So the answer is, although the transferor is not liable on the bill, the transferor is liable for damages for breach of warranty if the bill is not what it purports to be. So it's kind of the same thing anyway. Now, where an agent signs on behalf of a principal, the usual agency principles apply. The principal, of course, is liable. If the agent does an unauthorized act, in other words, he signs the bill without authority, the principal might still be bound on grounds of apparent authority. Of course, a principal can always ratify an agent's unauthorized act anyway. And the effect of ratification is that an unauthorized contract made by an agent becomes an authorized contract from when it was made. But a principal cannot ratify if forgery is involved. That's because the doctrine of ratification presupposes that the unauthorized transaction is valid except for the agent's lack of authority. And when the principal ratifies an unauthorized transaction, the defect in the unauthorized transaction disappears, and the unauthorized transaction becomes an authorized one, and the principal is bound. But if the transaction is defective for other reasons, you see, not just the agent's lack of authority, ratification by the principal can only remove the lack of authority. The principal cannot remove other defects over which he has no control. It is generally considered that forgery is such a situation. It is void in itself, aside from the lack of authority. So the transaction cannot be ratified by the principal. When an agent signs the bill, the agent must make it clear he signs as agent. He must put per pro or PP. Now, technically, PP should be put in front of the agent's name, not in front of the principal's name. So it should be like the top of this diagram. It's perfect. That's because, you see, the Latin phrase per pro means through the agency of. XYZ Limited is acting through the agency of Fred. Nowadays, of course, PP is taken to mean on behalf of. So PP is usually placed before the principal's name. It's technically incorrect, actually, but it's become such standard practice to write PP before the company or before the boss's name. That seems to be okay. See the bottom picture. It's not strictly correct, but it is accepted practice. Now, signing a bill with the word agent or director is probably not sufficient in its own right. The agent will be personally liable on the bill. Having said that, courts are very reluctant to find agents personally liable. Now, the liability of individual parties, we said only signatories to the bill are liable on it. Liability goes up the chain. If you look at the diagram on the screen, ultimately, it is the acceptor who pays. What happens at maturity is this. The holder presents the bill to the acceptor. If the acceptor pays, bang, the bill is discharged, end of story. But if the bill is dishonored, the holder has a choice. The holder can claim compensation against endorser number 2 or anyone else in the chain. That party then claims against his predecessor and so forth. ultimately the acceptor is the one who pays. I'll just say a couple of words about checks, because all checks are bills of exchange. So Section 3 conditions must be satisfied, but there are two main differences. With checks, the drawee is always a bank. The second difference is that checks are always payable on demand. But really, see, checks are very different to bill of exchange, because checks are usually paid straight away, because checks are payable on demand. Whereas bill of exchange are paid at a future date because it's used as credit. And checks are not accepted by banks, because if a bank bounces my check, the bank is not liable to the payee. The payee's remedy is against me, the drawer. The bill of exchange is often negotiated and endorsed to a third party. Checks rarely get transferred to third parties. I mean, you know what the pre-printed checks, they're often crossed, aren't they? Account payee. This means the check is not transferable. It can only be presented for payment through a bank account. So a check is not really a negotiable instrument. As I say, checks are bills of exchange, but they ought to be treated in a very different way. I mean, of course, there are other reasons why checks are still being used. I mean, they're hardly being used these days. I mean, we pay bills using other methods, but I suspect checks won't be totally abolished because charities and elderly groups, they want to continue using checks. Now, let's look at credit and security. Now, we don't have very much time, but let's do this in brief, because it is really important for you to have an overriding knowledge of the financial considerations of commercial transactions. Of course, you are already studying business association and it all connects. You have more detail in the handout and the course manual, and of course, you will cover much more in your business association lectures. Now, credit and security is very important in commerce. The focus of our commercial syllabus is transactions involving a business seller selling goods to a business buyer. Now, let's say I'm a seller. Well, I would like to be paid in cash, but we know this is not realistic. The buyer does not always have cash. He needs to sell his goods, he needs to sell his product before he can pay me. Sometimes I will accept a bill of exchange because that's virtually cash, so it's great. But even if I agree to take a bill of exchange, until the date fixed for payment, I need money to carry on my business. I have to pay my suppliers. I've got staff to pay. I've got office rent. I don't want to sell the bill of exchange for discounted cash. So how can I resolve this? Well, I need credit facilities with a bank or a lender. Most businesses need credit facilities to operate. Even the most profitable businesses need credit facilities. Lots of banks and financial institutions are willing to offer facilities, but their number one concern is getting repaid. They want security to ensure they get repaid. Now, if the debtor is creditworthy business, then maybe no problem, but there is always a risk that the debtor goes bust. Even if the debtor has always been creditworthy, it does not mean he can pay in the future. Maybe horrible things happen outside anyone's control. Maybe world recession, maybe COVID restrictions, maybe financial collapse of the debtor's customers. All of these things are beyond the control of the debtor. So the idea is this: the creditor lends me money or he agrees an overdraft. In other words, the creditor gives me credit. I give the creditor security. That's why the topic is called credit and security. Now, if the buyer goes bust, the general rule is that the creditors are treated pari passu. In other words, on an equal footing. So all the creditors will share the money in proportion to their claim. but the creditor hardly ever gets repaid the full amount. And there is no point suing the debtor if the debtor has gone bust. That's why the creditor wants security. Not only that, he wants to make sure he ranks in priority over other creditors. Needless to say, a secured creditor is in a better position than an unsecured creditor. The main advantage of taking security is that it gives the creditor rights against specific assets of the debtor. The creditor also has priority over other creditors. It is also a more efficient way of recovering claims against the debtor, because sometimes, you see, the creditor has the right to appoint the administrator or receiver over the assets. In general, there are two types of security. There's real and personal. Each type of security grants different rights to the creditor, so it is important to distinguish them. Real security is proprietary interest, it's proprietary security. It gives the creditor real property rights over debtor's assets. Pledge, lien, charge, mortgage. These are the four we'll briefly look at. So the debtor goes bust, the creditor can retake goods or has priority over other creditors. Personal security involves a third party. So a third party will guarantee the debtor's debt. This is sometimes called quasi-security. In general, real security gives the creditor better protection than personal security. Let's look at real security first. Real security is where the creditor has real property rights over the debtor's assets. Now, security can be possessory or non-possessory security. I mean, both have advantages and disadvantages. Possessory securities depends on the creditor having possession of the goods, like a pledge or a lien. Possessory securities historically were developed first, but they are not that useful really in the real world. It's the buyer who usually already has possession of the goods, because it is the buyer who either wants to resell them or use them to run his business. If the creditor has possession, how can that work in practice? Because the buyer can't use the goods to generate income nor sell it. Now, non-possessory securities do not depend on possession, like a charge or a mortgage. This is definitely more common. But a charge or a mortgage is not perfect either, because there's often more statutory control. So they need to be registered. This is for the protection of the third party. But overall, non-possessory securities are more common in practice, at least in transactions of any scale. The four types, lien, pledge, charge, mortgage, well, we'll concentrate on these a little bit. Now, lots of variants, of course, and Lord Millett's statement is in your handout, so please read that in your own time. But all real securities share the same two characteristics. Firstly, the seller can trace assets and proceeds into the hands of the third party, unless, of course, a memo doubt exception applies. Secondly, the creditor has priority over other creditors. Compare ROT. Retention of title clauses. Well, we mentioned words like tracing priority before, didn't we? We said the retention of title clause, ROT clause, has a similar effect. But ROT is not really a security device, not in law. That's because, you see, the seller is not taking security over the buyer's assets. The seller is merely reserving his rights. The ROT clause is merely saying the seller remains the owner. So the seller is not taking over the buyer's assets. The goods belong to the seller. So there's no point taking security over your own asset. Sometimes, some people call the ROT clause is as a quasi-security. Well, is the difference important? Well, yeah, it is. Because with unmixed goods, remember, ROT is effective. An ROT clause over unmixed goods does not need to be registered because it does not create a charge. If it's mixed goods or proceeds of sale is concerned, the effect of ROT is that a charge is created. Now it becomes a security device. So it now needs to be registered. Now, the creation of a security interest, usually security interests are consensual. In other words, it's voluntary. So the creditor and the debtor, they agree something, like a mortgage. So sometimes the law might require certain formalities. We know that a legal mortgage of land must satisfy the LPA, Law Property Act. But security interest can be non-consensual. It can arise by operation of law, for instance, like the lien. Now, there are 3 stages of creating a security interest. The first is attachment. This is where the security interest attaches to a particular asset. Now, the asset, of course, must be sufficiently identified. So the debtor says, I charge all my existing and future book debts. Okay. Can a creditor take security over future property? In other words, property that the debtor does not yet own? At common law, the answer is no, because there is nothing to transfer. But in equity, yes, it is effective. Security interest attaches when the debtor acquires the asset in the future. The second stage is perfection. Just because the security interest is created, it does not mean the interest binds third parties. In order for the creditor to have priority over other creditors, he needs to perfect his interest. This means doing whatever the law says needs to be done to make that security effective. For instance, registration under the Companies Acts. You see, third parties are expected to search the registry, so third party will know the asset is or is not encumbered. Registration, excuse me, provides notice of the creditor's security interest to the whole world. So registration therefore perfects the creditor's interest, and a registered security is binding on third parties. Remember, the whole point of registration is that third parties have notice that a security interest has been created. It protects third parties. Now, there is one exception to this rule: assignment. Now, unfortunately, we are not going to have time to talk about assignments, but assignments is a non-possessory security. It can be perfected without registration. How do we perfect possessory interests, such as a pledge or a lien? Well, possessory security is perfected by the creditor taking physical possession. That's it. That's because when the creditor has possession, it is pretty clear to everyone that the creditor has rights over the property. But with non-possessory securities, the creditor must register his interest. The third stage in the creation of the security interest is priorities. Now, although the general rule is pari passu, in other words, all securities are on an equal footing, some creditors rank in priority to others. Secured creditor has priority over unsecured, but even so, amongst secured creditors, there is a ranking. Needless to say, unsecured creditors are pretty much at the bottom. They are unlikely to get anything after all the other creditors have been paid. Anyway, we don't need to know much more than this for our commercial law syllabus, so I won't say anything more about priorities. Let's look at the 4 types of real securities. The pledge is where the creditor takes possession of the debtor's asset as security until he gets paid. The typical example is the pawn shop. So the pledgee is the creditor. He is the bailee of the asset, and he owes the pledgor, that's the debtor, a duty of care. The creditor does not have to have actual possession, of course, because constructive possession is okay. So for instance, if I pawn my jewelry, I can give the pawnbroker the keys to my safe because that's where I keep my jewelry. Now, pledge is a very powerful form of security interest because the pledge is only released when the loan is repaid. Having possession gives the creditor special property in the goods. He does not become the owner, of course, but the creditor has the implied power of sale if the debtor defaults. There is no need to register a pledge because the creditor has possession. The third party knows that the creditor has rights over those assets. But in the modern world, the pledge is not used that much because, for a start, a business debtor needs to use the asset to generate income. So unless the creditor literally occupies the same factory space, the business debtor cannot use the machine. The second reason is that the pledge only works with physical assets, like a machine or a bill of exchange, which, as we know, is a physical piece of paper. A pledge cannot apply to intangibles like information on an electronic database. It cannot apply to, say, Bitcoin. Let's look at the lien. The difference between a pledge and a lien is this. A pledge is when the creditor has possession of goods to secure a debt, money. If the debtor does not pay, the creditor has the implied power of sale. So the lien on the other hand, is when the creditor has possession of the goods for something else. For instance, the motor car dealer has my car to repair it, to store it, this type of thing. The creditor has a lien over my car. The motor car dealer has my car to repair it in some way. The creditor has a lien over my car in his possession until I pay that repair bill. In fact, there are lots of types of lien. The first lien is a common law lien, and there are two types. The first is a particular lien. This is where an agent has a lien over property which comes into his possession in the course of agency. The agent can hold property until he gets paid whatever is owed to him, like, for instance, his commission or indemnity. The second type of common law lien is a general lien. This is where an agent has a lien over all property until the principal pays all the claims of an agent. Now, an agent usually has a particular lien unless trade or custom kicks in. So, for instance, bankers and solicitors, they have general liens. A banker can take money from any account you have with them to satisfy a debt. The second type of lien is the statutory lien. Section 41 is not in your syllabus, 41 of the Sale of Goods Act. That just says that an unpaid seller has a lien over goods in his possession till the buyer pays him. There's a fourth type of lien, maritime lien. It's not in your syllabus at all. Forget it. We're looking at the types of real security. We've just looked at pledge and lien. Let's just mention the mortgage. Now, a mortgage can be a legal mortgage or an equitable one. Legal mortgage is, of course, the best. It's the most secure form of security interest. And a mortgage can be placed over high quality assets like property and land and aircraft, ships, that sort of thing. A legal mortgage is where the debtor transfers ownership to the creditor subject to the debtor's right to redeem the mortgage. So the creditor becomes a legal owner. The creditor has the right to immediate possession. Usually, of course, the creditor won't exercise the right to immediate possession unless the loan is not repaid and the debtor defaults. Now, the mortgage, of course, only exists for a period of time that any credit is outstanding. On repayment of the full amount, the legal title of the asset reverts to the debtor. The creditor then has zero interest in the asset. So No particular formalities are required except, of course, a mortgage of land. Now, mortgages of land is a special type of mortgage and it's governed differently, and it's certainly not within your commercial syllabus. Now, mortgage is a very useful security because there is no transfer of possession, and the creditor can take a legal mortgage over all types of assets. Tangible assets like ships and aeroplanes, as well as intangible assets like copyrights and patents. But it must be existing assets, though. You cannot create a mortgage of future assets. But the best feature for the creditor is the power to foreclose. If the mortgagor, that's the debtor, does not pay, the creditor can sell the asset to discharge the debt. Mortgages are very widely used in practice. Now, the equitable mortgage is where the debtor transfers beneficial interest in the asset. Full legal ownership remains with the debtor. How do you create an equitable mortgage? Well, if the formal requirements of a legal mortgage are not satisfied, then the courts will recognize a mortgage in equity. So, for instance, a mortgage over future assets. That's because legal mortgage can only be created over existing assets. Now, equitable mortgage is also created where only equity recognizes mortgage over certain types of assets. For instance, an interest in a trust fund. See, a legal mortgage can't be taken over these types of assets. But equitable mortgages do not give creditors much protection, though, and they are very difficult to enforce. That's why a legal mortgage is better for the creditor. The fourth type of real security is the charge. Now, all charges are equitable charges. Technically, there's no such thing as a legal charge. But the words charge and mortgage are often used interchangeably, but they are legally different. See, a mortgage involves me transferring ownership in goods to you, subject to my right to getting it back when I pay off the loan. A charge gives you rights over my goods as security for a loan. Now, the charge is a very useful security. Three main reasons. First of all, the charge does not involve the transfer of possession, and there's definitely no transfer of ownership. Most lenders do not want possession of assets. Borrowers do not want to lose control anyway, especially if I need the asset to be used on a day-to-day running of my business. Second reason why charges are useful is because as far as mortgages are concerned, a debtor cannot create a mortgage of future assets, but he can with a charge. That's because a charge is created in equity. Charge attaches to the asset when it later comes into the debtor's ownership. Thirdly, a charge and a mortgage sounds similar, but the remedies for non-payment is very different. If I don't pay my mortgage, the creditor's rights to foreclosure are more extensive than the right available to the charge holder. Having said that, in practice, they are not too different because the creditor will use it to put it, because the creditor will usually put an express term in the contract to say that the seller can sell the asset. The question is whether corporate or personal guarantee from the get can be assigned to others. We're going to come to personal securities later, all right? Now, a charge can be fixed or floating. Whether it is fixed or floating is very important. A fixed charge attaches to an asset as soon as the charge is created. The charge remains in place until the loan is repaid. The debtor cannot dispose of the asset without the creditor's consent. But a fixed charge can only attach to a fixed thing that is not going to change. This particular machine, this ship. The debtor needs the creditor's permission to add a second charge. But you see, the problem is a fixed charge cannot attach to, for instance, raw materials, because the buyer needs to use those materials to make goods. Fixed charges can therefore be restrictive, but the creditor has no need to call in the terms of the charge if repayments are made on time. Compare the fixed to a floating charge. Now, not every business owns assets capable of a mortgage or a fixed charge. Maybe the business premises or maybe the machine is on hire purchase. That's where a floating charge comes in. This is a charge, this is a security over a group of assets. It hovers, it floats over a class of assets. So the assets are described in general terms only. For instance, the debtor's trading stock or all stock and inventory. Assets fluctuate because the debtor can sell them or acquire further assets after the floating charge is created. So the creditor's interest is in a changing fund of assets. If the borrower goes bust, or the lending contract says on the occurrence of a certain event, normally non-payment, then the charge crystallizes. This means that floating charge becomes fixed to assets. The asset can no longer be dealt with by the debtor without express permission from the creditor, and the creditor uses the assets to pay that debt. Now, flexibility is the great advantage of the floating charge. But because the debtor is free to use the asset, the creditor has a problem, doesn't he? How does the creditor stop the debtor from disposing of all the assets? That's why lenders prefer to take a fixed charge if possible. In practice, the lender gets best of both worlds because they will use a combination of fixed and floating charges in one document called the debenture. So the document will create fixed charge over certain assets like land or machinery or goodwill, and a floating charge over all other assets, because the floating charge then acts as a catch-all. By using this combination, the creditor is covered if anything goes wrong with the debtor's business. Right. Well, a word about registration. Now, charges are tricky for third parties. Because the debtor remains in possession, the third party does not know if there are any encumbrances over the asset. The third party does not know if there are any charges. That's why, if a company is involved, the creditor must register that charge under Companies House, Section 859A. Otherwise, the charge is void under 859H and so is unenforceable against liquidators. We know this from ROT. Registration is for the protection of the third party. But the reason why the creditor sometimes does not bother to register the charge is because, as I said, it's a bit of a nightmare system, really. You need to complete these forms and deliver them to the registrar of companies within 21 days of creation. Now, there is a cost, of course, to register your charges as well. Online, of course, is cheaper. But the registry of company charges is a public document. Anyone can inspect it for a small fee. Of course, it's not a criminal offence if the creditor does not register the charge. It's just that if the creditor does not register, it means the charge is void against the liquidators. And that defeats the whole object, the whole purpose of taking a charge in the first place. Now let's look very quickly at personal security. Now, real security gives the creditor real property rights over the debtor's assets. Personal security gives the creditor rights against a person. It involves a third party. The third party guarantees the debtor's debt. This is often known as quasi-security. Now, quasi-security is not the same as security. Real security creates rights against assets, whereas Quasi-security creates rights against a person. It involves two agreements, essentially, between the creditor and the debtor, and then between the creditor and the guarantor. Essentially, it is a contractual arrangement whereby one party agrees to be responsible for another's liability. Both the debtor and guarantor promise to pay. Now, the debtor has the primary responsibility to pay. The guarantor has the secondary responsibility to pay. So the debtor fails to perform the obligations which have been guaranteed, the guarantor then becomes liable. This is very common. Of course, the creditor will only accept personal security from a credit-worthy person, because the guarantee is only as good as the person who gives it. Compare that with real security we just looked at. The value of real security depends on the value of the property over which the creditor has security. Now, there are lots of types of personal guarantee. There are letters of comfort, for instance. These are often used by a parent or a holding company giving comfort to a lender about their support for a subsidiary. Comfort letters do not create rights over assets. And to be frank, in many cases, they won't even be legally binding. Not much use, really. They are only really provided if, for instance, the holding company can't give a guarantee because the memorandum and articles of association prohibit the giving of guarantees, or maybe there is already a negative pledge, so the holding company cannot give priority to any other lender. Another type of personal security is a contract of indemnity. This is where the surety promises to be responsible for third-party liabilities. The surety has primary liability. An indemnity is similar to an insurance contract. It's a way of allocating and managing risk. The person providing the indemnity is called the surety. So if XYZ happens, the surety agrees to pay for the loss or damage. Another example of a personal security is negative pledges. Now, a negative pledge is often considered a quasi-security because it is used to protect the lender's possession. But a negative pledge does not guarantee, does not create a security interest, because a negative pledge does not give the lender property rights over the borrower's assets. A negative pledge is a contractual arrangement whereby the borrower agrees not to create encumbrances over its assets. It's basically the borrower agreeing not to restrict their freedom over use of its own assets. It doesn't give the lender rights over those assets, but it gives the lender the knowledge that the borrower will agree not to deal with the assets in a certain way, in a negative way. Now, I'll just mention the contract of guarantee. See, a guarantee is used to protect a bank or a financial company against loss if the borrower fails to pay or perform its obligations. It gives the bank the right to demand payment from the guarantor if the debtor defaults. If the debtor has primary liability to pay, the guarantor has the secondary liability. Only if the debtor does not pay, the bank will ask the guarantor to step in to pay the bank. The usual contract rules apply to contracts of guarantee. Yes, it is supplemented by statute, but contract rules still apply, offering acceptance, consideration, that sort of thing. Now, the statute of frauds, of course, does require a contract of guarantee to be in writing and signed, because once the guarantee is effective, if the debtor does not pay, the guarantor must pay. If the debtor pays, the contract of guarantee is discharged. Now, whether these guarantors can be assigned to others depends on your specific contract of guarantee. It is treated as any other contract. There are special formalities, sure, but all the other contractual rules apply. Now, I think we end there. We've done some massive work. We've done some very good work. And commercial law is such a big, big syllabus. And we've managed to cover most of it. We don't have the time left to do any justice, to cover assignment, and we certainly have no time for bank customer relationships. So we will not examine you on those topics. You will not be examined on anything I have not covered in class in main lectures, but we have covered a lot, and we did manage to look at exam questions so you know the standard we expect. Now, of course, the revision course will be sometime next year. We will give you an indication at that stage as to whether an examinable topic will be an essay question or a problem question. But as I mentioned a bit earlier on, there are some questions which are invariably problem questions, like transfer of property and risk, like Section 13 and 14 of the Sale of Goods Act, like the 1982 Supply of Goods and Services Act. Those are usually problem questions. But NEMODAC can be either way, sometimes problems, sometimes essays, but we will give you, as I say, an indication at the revision course. You need to answer 3 out of 6 questions. You will have 3 hours plus some reading time. As I've already said, what is really, really, really important is you watch your time. Don't spend so much time on answering just 2 questions that it leaves you with hardly any time left to answer the 3rd question. The number of times we see this in the exam booklet is ridiculous. You cannot get good marks in that way. You must plan your answer. Do rough work so you know what you need to cover. Then, when you get to 1 hour on one answer, just stop. Even if you haven't quite finished, you must go on to answer the other 2 questions. If you have some spare minutes, then go back to the question you didn't quite finish. But do not overrun on time, please. That's your biggest danger. All right, well, let's end there. Thank you for attending these lectures. It's been my pleasure to take these classes. I wish you all the very best. Study hard. Bye for now. Bye for now.